Hello. Well, good morning. Well, welcome everybody. I'll give it a couple of minutes or a couple of moments for people to be admitted into the webinar. But morning all. Many thanks for joining us on what appears to be a bit of an annual tradition at the moment to unpack all things pre-Christmas consultation and a revised national planning policy framework. Great to see so many people joining us today. Just whilst people join the webinar, and by way of introduction, I'm Jay Meta. Many of you may know us, but I head up our planning team here at Howes Percival. I'll do an introduction to the other speakers in a moment. But before we turn to the detail of what we're going to be talking about, a couple of housekeeping points in the usual way. Um, all microphones should be muted, so no need to adjust your personal settings. Any IT issues, do pop those in the question and answer function, and we will endeavour to sort those. And equally, if you're disconnected, then please rejoin the webinar using the same link provided. The webinar is being recorded, which we'll share at the end of the session, along with feedback forms. In the usual way, feedback's really important to us, quality content of the webinar, and indeed anything that you would like us to pick up at future sessions, please do provide your feedback. As I say, any questions we'll endeavour to answer at the end. Please pop questions in the question and answer session. Any questions that we do not get around to answering, we'll endeavour to come back to you directly, or alternatively, do get in touch with one of us. Needless to say, there's a huge amount to unpack here. We're going to try and cover practically as much as we can from the consultation material and the revised framework. And we're planning to speak for about an hour, maybe a little bit more, and then we'll have sufficient time for question and answers at the end. So moving on to our speakers, um, you know who I am. Delighted to be joined by fellow partners Jamie Charles, Paul Hunt, and Marco Moro, Senior Associate Beth Boucher, and Associate Morgan Stacey, spread across our offices, across the Eastern region and the Midlands. So delighted to be joining you today. So this is what we're going to be talking about, and there's a little bit to rattle through, as you can imagine. I'm going to provide a little bit of context to these proposals and some of the other things that came out pre-Christmas that's important for us to be aware of. Morgan's then going to pick up on navigating one's way around the revised framework and how it operates. Paul's going to pick up plan making policies. Beth is going to pick up the new presumption in favour of sustainable development and decision making. Marco will pick up green grey belt. Jamie will deal with the best of the rest and his personal highlights in that regard. I'll give a brief nod and update to parallel statutory regimes in foul water, as this is a big point that's affecting schemes across the country at the moment, before then moving on to questions at the end. So what do we have? And these are all of the documents that landed with a thud on the 16th of December. I've got links to the slide, which of course you can access when we circulate those at the end of the session. So for a third year running, we've unwrapped our early Christmas present from government in the form of the raft of new planning proposals and consultation documents, which, as I say, landed with a thud on the 16th of December. I've listed those. We've got the press release, the WMS, the letter to the LPAs, and importantly, the consultation paper with no less than 220 odd questions, along with the consultation draft NPPF, which includes the national decision-making policies. Now, the extent of the consultation material is unsurprising. The foreword effectively from government to all of these proposals was, well, England is, and I quote, in the grip of a housing crisis, and ultimately the proposals are aimed to enable delivery of hundreds of thousands of homes across the country, and I quote, thanks to the most significant rewrite of planning rules within a decade. Now, ultimately, I think as we work through the framework, I think we'll all be able to reach the conclusion that this really does move the dial positively forward. It is a significant step forward. But ultimately, this is the critical point for me when we're looking at the consultation documents and responding. Are these changes ultimately going to help enable housing delivery of other developments and infrastructure projects much more efficiently and in a quicker way, whether that be immediately or indeed in the future when the framework beds in. Now, ultimately, that's something I think we'll have in mind when responding to the consultation, something that will be picked up through the various topics. Next slide, please, Jamie. So turning to some of the practicalities around this. Well, as I've said, there's a huge amount to unpack here. How many of us tried to run the comparison software between the current framework and, of course, the consultation draft MPPF? Entirely pointless exercise. It's a significant rewrite. Um, and given the extent of material that we need to consider, the rewritten framework, which now includes, of course, the NDMPs, it's understandable that we've been allowed a good period of time until 11:45 p.m. on the 10th of March this year to respond to the consultation. Now, all of us need to look at the consultation document. We need to look at it in detail and air any concerns and offer suggestions on how it can work more effectively. Us lawyers, of course, will be looking at it to try and confine any areas of potential debate, challenge in terms of the policy wording. And whilst it's unlikely from history and past experience, at least, that government are going to be significantly rewriting this following a consultation. They do want to move at speed, and it's important that we suggest any tweaks so it can operate much more effectively. So moving on to the big question, the big debate that's been had at water coolers up and down the country. Are the NDMPs going to be non-statutory or statutory? Now, government have confirmed that at the current time, at least, NDMPs will be non-statutory. So what that means is that the status quo under Section 38(6) of the Planning and Compulsory Purchase Act 2004 is preserved. And the starting point, as we all know, applications must be determined in accordance with the development plan unless material considerations indicate otherwise. And the framework, of course, is a material consideration of significant weight. So it is government's decision not to place NDMPs on a statutory footing a missed opportunity. It's been over 2 years, of course, as we know, since the Levelling Up and Regeneration Act 2003 that placed NDMPs or created the framework for NDMPs to be on a statutory footing. And of course, that hasn't now been brought into force. Now, I personally see both sides of the argument. On one hand, streamlining the planning process goes directly hand in hand with placing NDMPs on a statutory footing. Ultimately, if that were the case, then under the 2003 Levelling Up Regeneration Act, NDMPs, planning applications must be determined in accordance with NDMPs and the development plan, unless material considerations that was proposed strongly indicate otherwise. But in the event of conflict between the development plan and NDMPs would trump. Now, of course, that's not the case here. In a development management context, as we all know, essentially the framework has a lesser status than the development plan, and it is possible for decision makers to consider the framework as a material consideration and ultimately conclude that the development plan should be followed, notwithstanding what the framework may say. So at least that brings some level of uncertainty, I think, for the industry. And same concerns apply to plan making. And the whole point of NDMPs and for them to be on a statutory footing was to avoid the risk of duplication through the local plan process. But of course now that duplication may, in theory at least, arise. And of course, we've got specific policies which Paul will cover within the framework that suggests that local planning authorities can suggest bespoke policies to deal with local issues through the local plan examination stage. So ultimately question whether or not non-statutory basis is ultimately going to be speeding up local plan making within that 30-month period as proposed in the manner envisaged. Now, all of that said, I personally understand the concerns. On the other side, not putting these on a statutory footing potentially avoids some of the legal consequences and delay. strategic environmental assessment, for example, the need for secondary legislation, parliamentary approval, and of course the further risk of legal challenge associated with those. Now, non-statutory policy may provide a much more versatile and agile way to deal with policy issues on a national level moving forward, as we've seen, of course, from the no less than, I think, 6 iterations of the NPPF since its inception in 2012. So critically for me, it's about how this is all applied in practice. If decision makers and examiners in the context of local plan examination apply NDMPs in the manner that government intends to avoid duplication, to avoid unnecessary debate, etc., then ultimately in practice, some of the fears around statutory v non-statutory footing may be alleviated. So what now? And what do we do with this raft of consultation material at the moment? Well, as Morgan will pick up, the framework will apply from the date, in the context of decision making, the policies will apply from the date of publication. So applications that we're currently reviewing, and of course many of us will be preparing, need to give a nod, I think, to the direction of travel under the NPPF, because it's likely that when those applications are determined, particularly in an appeal context, the framework may be published. Now, whilst we may not be expecting significant change, I think it's important to make sure that those proposals ultimately are addressing, in substance, any revised policies that may be coming through the NPPF. Whilst the framework, as I say, is likely to be a direction of travel, I think it's difficult to attach anything more than limited weight to it at the moment. In terms of the written ministerial statement, we know from cases such as West Berkshire in the context of affordable housing and the written ministerial statement 2014, Court of Appeal decision 2016, that written ministerial statements are capable of being afforded significant weight. But in my mind, given the contents of the WMS, I don't think that's going to be a determinative factor that pushes towards approval, as opposed to a world where there is no WMS, for example. So moving on to some of the other stuff that we saw pre-Christmas. I mean, government's clearly moving at pace. 18th of December, we also had the Planning and Infrastructure Act 2025, as Paul will pick up, and that creates the statutory framework for spatial development strategies. The same date, we had some commencement regulations, as I've got on the screen, and importantly, commencement regulations under the 2025 Act that allows Natural England to push on with the preparation of environmental delivery plans to address matters such as nutrient neutrality, for example, and get going on those. We don't have any levy regulations at the moment, but ultimately it's good that Natural England can push on with those. 6th of January 2026, national policy statements for energy, renewable energy and electricity networks were published. And also on the 8th of January, just this year, we've had regulations to allow data centres to be directed towards the NSIP regime. So lots going on and plenty that we can digest at future seminars, which I'll pick up towards the end. So I'll now hand over to Morgan to start unpacking the NPPF in a bit more detail. Thanks, Morgan.
Thank you, Jay. Good morning, everyone. My name's Morgan, and I'll be discussing the structure and operation of the proposed NPPF. So to start, visual form. There have been some presentational changes. The proposed NPPF is visually different to the existing NPPF, and from a first glance, the proposed NPPF is drastically different. I think much of that, however, can be attributed to the structure and layout changes. So first off, the sequential numbering has been replaced with local plan styled numbering policies. And the purpose of this change is for ease of reference. Of course, clarification of the existing NPPF is welcomed, but I do think that some of the new numbering is rather laborious when referring to certain sections. The NPPF has been reordered and restructured around policies within thematic chapters. The intention behind this restructure is to improve clarity, usability, and consistency throughout the NPPF. Ultimately, national planning policy is to be accessible and usable by users. These thematic chapters now include objective boxes at the start of each chapter. More on that in a moment. The proposed MPPF, sorry, Jamie, please could you go back a slide? Thank you. The proposed MPPF contains both revised plan making policies and national decision making policies in one document. The consultation text advised that separating plan making and decision making material has required extensive redrafting. It is true that the proposed MPPF is not short and sweet, but about twice the length of the existing MPPF. But I do think that the proposed MPPF is logically structured in its approach. And of course, it's positive that changes have been made to improve the navigation and operability of the document. Is it as clear as it could be? Perhaps something to think about. Content-wise, some things have changed and some things have stayed the same. My co-presenters will be discussing these changes in more detail throughout this webinar. In terms of navigation, we start with the introduction, followed by general procedural policies for plan making and decision making. Subsequent chapters contain policies on thematic issues, separate into policies for plan making and decision making. And lastly, there are annexes A to F, which are also national planning policy, as confirmed by paragraph 9 of the introductory paragraphs. Next slide, please, Jamie. So focusing now on objectives and chapters. As I mentioned, chapters now begin with short objective boxes, setting out background and purpose for the relevant chapters. Paragraph 10 of the introductory paragraphs emphasises, however, that objectives are for context only and not to be applied as either plan making or decision making policies. Thematic chapters deal with individual topics. These chapters separate policies into those that relate to local plan making and those that relate to decision making. Paragraphs 6 and 7 of the introductory paragraphs confirm that plan making, paragraph 6, and decision making, paragraph 7, should be read as a whole, including relevant footnotes and annexes. Paragraph 8 provides that the purpose of setting out plan making and decision making policies together is that they are to be seen in the round, but they are not intended to cross over. Lastly, plan making policies should not be used when making decisions on development proposals. Presumably, the courts will need to tackle potential overlaps should the final version of the proposed MPPF substantially resemble this draft, as it is quite possible that there will be situations where plan making policies do have some relevance to the decision making process. Next slide, please, Jamie. So, how is the proposed MPPF going to be implemented and what happens when there are inconsistencies? Well, for the purpose of decision making, paragraph 2 of Annex A deals with the weight that should be given to inconsistencies between development plan policies and national decision making policies. Development plan policies which are in any way inconsistent with national decision making policies outlined in the MPPF should be given very limited weight in decision making. An exception to this would be where local policies have been examined and adopted against the proposed MPPF. It's likely that there will be an overlap with many development management policies, and the consultation text confirms, however, that the overlap is intended to fall away eventually, with plans being prepared against the new proposed MPPF. For the purposes of plan making, paragraph 8 of Annex A provides that plans currently proceeding under the existing regulations should be produced in accordance with the existing NPPF, subject to any transitional arrangements to Annex 1 of the existing MPPF. The status of proposed MPPF for plan making is that development plans are not required to follow the proposed MPPF until the final version is published. So the extent of this will depend on final transitional arrangements. Next slide, please, Jamie. What is the intended relationship between the MPPF and Planning Practice Guidance, PPG? So paragraph 13 provides that the PPG is to play an important but supporting role to national planning policy and should be regarded in that light. The implementation of the NPPF is supported by PPG, but paragraph 13 makes clear that PPG should have a supporting role only. The proposed NPPF contains several new annexes containing key technical reference information, for example, the standard methodology for calculating housing need. And the consultation text confirms that additional annexes are proposed to be added to the draft NPPF, some of which will import key aspects of PPG, which are considered essential for the operability of the NPPF. So it sounds like we're entering the territory of the NPPF Extended Edition. Well, that is all from me on the structure and operation of the proposed NPPF, and I will now hand over to Paul, who will be covering plan making.
Thanks, Morgan. Good morning, everybody. As Morgan's already indicated, the draft NPPF is structured by way of policies in a similar way to a development plan. And the basic split is between decision making and plan making. And I'm going to be dealing with plan making today. I'm sure we're all familiar with the role of development plans. We operate a planning system that is meant to be plan-led. We are also no doubt familiar with the fact that the plan, once it's adopted, has statutory force and has primacy in the decision-making process. And that is encapsulated, as Jay has already touched upon, in Section 38, subsection 6 of the Planning and Compulsory Purchase Act 2004. Very simplistic, of course, but we would normally expect that any development proposals that are in conformity with the plan to be permitted, and those that are not in conformity with the development plan to be refused. I appreciate, as I say, that that is a very simplistic approach, and there are many other factors to be taken into account. But we all get the gist, and we all understand, therefore, the importance of having a development plan. But equally, we are aware that there has been problems with that system, primarily the time it takes local planning authorities to prepare and adopt local plans. Typically, on average, it's taking about 7 years to produce a local plan. And then, of course, once adopted, the plan has to be kept under constant review to see whether or not revisions are required, and at least every 5 years. And in many instances, that simply isn't happening. We are all no doubt familiar with the fact that a number of local authorities put their plans on hold, or sometimes simply abandon them, particularly if there are changed circumstances. Typically, we've seen this in relation to changes in government policy to calculating housing need and housing requirements. And that is part of the dilemma, that government policy changes rapidly, but the plan-making process is rather slow and cumbersome and simply cannot keep pace with those changes. And for many local planning authorities, no doubt they feel that the goalposts are constantly being changed by government. There's also, of course, issues surrounding resourcing for local planning authorities and the resources that they have to devote to the preparation of development plans. And we've seen these problems reflected in the NPPF and the current NPPF, Para 11, and the presumption in favour of development, which arises in circumstances where policies in the local plan are absent, silent, or out of date. So that, I think, is a reflection of the difficulties that we are encountering with the plan-led system. So what are the changes that are proposed? Well, essentially, in terms of local plans, the idea is to pare them down significantly in 2 ways. Firstly, to remove from local plans development management policies, This is not a new concept, of course. It was introduced by the last government, and I'll turn to that in a moment. At the moment, many local plans have development control policies, development management policies. They say broadly similar things, albeit in a slightly different way. The idea, sorry, Jamie, could we get the next slide? The idea of national development management policies is, as the name implies, that the government will have a raft of development management policies that all local planning authorities will have to work to. The idea is to provide clarity and hopefully consistency in decision making, and therefore right. I hope everybody can hear me. Sorry, my screen froze there. What's in a name? Well, as Jay has already indicated, the policies themselves will not be statutory. The government could have put them on a statutory footing by virtue of Section 93 of the Levelling Up and Regeneration Act. That actually makes amendments to Section 38 of the Planning and Compulsory Purchase Act 2004 by making NDMPs statutory, and as Jay has already indicated, where there is a conflict between NDMPs and the policies in a development plan, the NDMPs will prevail. But the government has decided not to do that, and Jay has already indicated what the ramifications of that may be. But clearly, going forward, if NDMPs are not to have statutory effect, then the potential conflicts between those and local plan policies may continue to give rise for debate and discussion in terms of the decision-making process when it comes to the determination of applications and appeals. Next slide, please, Jamie. So the next change is the introduction of spatial development strategies. So we remove development management policies from local plans, and it's intended that any strategic policies will also be removed from local plans, and that they will in turn be addressed by spatial development strategies. And the NPPF sets out the purpose of these SDSs, and you'll see from that slide before you that it's to set a positive vision for the future growth and change at a sub-regional scale and provide a clearer spatial framework for investment and growth, including new housing. And then policy PM1 sets out the role and functions of SDSs. I won't go into those, but you'll see some of the key aspects of SDSs set out in that slide. So turning to the next slide and the current system and how it operates and why we are seeing these changes. The statutory context for making SDSs, as again Jay has alluded to, is the Planning and Infrastructure Act 2025. We have had in the past strategic planning, so-called top-down planning. I'm certainly very familiar with it, and many others on this webinar will be familiar with the old strategic policies and even going back to the days of government offices, where, for example, housing numbers were set at a regional level, then at a county level, and then at district levels, with the housing figures cascading down, with the local authorities allocating land to meet the requirements imposed upon them. That all went by the board as a result of the Localism Act 2011. And now any strategic policies are meant to be addressed in local plans and through the duty to cooperate between local authorities. So strategic issues that go beyond one local authority's area are to be addressed by cooperative working between two or more local authorities. But the government clearly feels that that is not working sufficiently well, and that's why the proposal is to introduce spatial development strategies. So who will be the strategic planning authorities that will make these SDSs? Well, essentially, it'll be unitary authorities, and it will be collective authorities, including county authorities, those authorities that come together, as at the moment they do, to work on joint plans that address strategic issues. So what are the issues going to be going forward? Well, the problem, of course, is that this introduces yet another tier of plan making. The local plans will have to conform to the policies in the SDS, and this may be a basis for some local plans being delayed until the SDS is prepared and adopted. They will be prepared and examined in the same way as a local plan, broadly speaking, but there is no clear time frame for the introduction of these SDSs, and in due course regulations will be made that will prescribe the procedures to be followed and the timeframes to be followed. But ultimately there's no clear time frame in terms of their introduction. So the effect could actually be to delay further the adoption of local plans once the preparation and adoption of SDSs takes place. And there's also, of course, still the issue of funding for the preparation and production of these documents. And we need to bear in mind, of course, that the current government may not be in power in 3.5 years' time. And a changed government may not favour the introduction of this strategic layer of plan making, such that no SDSs are even prepared or certainly don't get as far as adoption. So a number of issues are there going forward. Next slide, please, Jamie. So that sort of brings us finally to local plans and what's left of local plans. As I say, local plans will be pared down quite significantly. No development management policies or decision-making policies, whichever terminology you prefer, no strategic policies. Basically, local plans should focus only on local issues that are confined to an individual authority's area and nothing more. For the most part, of course, local plans will primarily have the role of allocating land still to meet the needs for housing and employment in an individual authority's area. The government aspire to these plans being produced in just 30 months, although the actual process underpinning the preparation of the local plans can and indeed will start before that 30-month starts. So in reality, it could take quite significantly longer even than the 30 months to prepare a local plan. And it's quite clear from policy PM6 of the draft that it is expected that the policies in a local plan will not duplicate, substantively restate, or modify the NDMPs. So going forward, although there is this potential conflict between NDMPs, which will not be statutory, and adopted plans that will be, as time progresses and development management policies disappear from local plans, then there shouldn't be that element of conflict in any event. So there's quite a bit in the offing, a number of changes. I think it's a good thing that we are going to have national development management policies. Hopefully, it will provide some consistency in decision making. I agree with Jay. Remains to be seen what the effect of not making NDMP statutory will be, but it's quite clear that the government will keep that under review. And if circumstances justify it, there's every chance that NDMPs would be put on a statutory footing, whether that's by bringing into force the provisions of Section 93 of the Levelling Up and Regeneration Act or otherwise. So we'll just have to wait and see. And on that note, I'm going to hand over to Beth.
Morning, everyone. Hopefully you can hear me okay. So as Paul said, I'm going to move away from plan making and into decision making. And this will, of course, be probably the first battleground once the NPPF takes effect. It will, of course, be months or years for new plans to be drafted, examined and approved. But the reforms affecting decision making, as Morgan said, will be immediate when the NPPF comes into force. So it is important to be considering these now, particularly in the context of any new applications being submitted. It does seem very likely that most applications being worked up at the moment will be determined in the new era of the NPPF 2026. As Jay said, we do only have a draft text at the moment, but it seems to be a fair assumption that whilst there may be some minor tweaks in the final NPPF, the principles should remain largely the same. So what are these changes in terms of decision making? So the major change is that we will no longer have paragraph 11 and the tilted balance. We'll no longer have to grapple with considerations of whether a policy is out of date or which policies are within the basket of most important policies. But rather, the new NPPF introduces a series of presumptions in policies S3 to S6. So if I could have the next slide, please. So to briefly summarise, the first policy, S3, provides a new presumption in favour of sustainable development. So it confirms that proposals which accord with an up-to-date development plan should be approved without delay, so far no change. But how the presumption then applies depends upon the location of the development being proposed. And the aim of this policy is to selectively steer the location of development, and in particular, we're told, to urban brownfield locations. So within settlement boundaries, and if I could just have the next slide, please. Yes, within settlement boundaries, and we'll come back to what that means, proposals should be approved unless the benefits of doing so would be substantially outweighed by any adverse effects when assessed against the national decision-making policies in this framework. So there's no footnote 7, no reference to local plans or to 5-year housing land supply. But we are given some guidance as to when it's considered under the NPPF that the benefits of a development are likely to be substantially outweighed by its adverse effects. And it should be noted that there is a specific reference to the failure to comply with other policies in the NPPF where those policies state that development should be refused as being likely to be reasons to justify disapplication of the presumption. Of course, we're using terms like likely and should, and that does, of course, leave room for a decision maker to conclude otherwise when applying their planning judgment. So moving on to the next slide. When we are outside settlements, there remains a presumption in favour of specific types of development. This is a closed list, and where the proposal lies outside those types of development, the NPPF confirms that approval should only be given in exceptional circumstances. So essentially what we're left with outside of settlements is a reverse presumption against development. And of course, what will contribute exceptional circumstances is likely to prove a future battleground. So just moving on to the next slide, I've set out the list of developments which are considered to be acceptable outside a settlement boundary in summary. So it includes, for example, allocated land, redevelopment of buildings, and things like exception sites. But I'm going to briefly pick up on two of these exceptions in a little more detail. So next slide, please. So taking the second first, this is development which meets an evidenced unmet need, which is well related to a settlement. So that's Lim J. And this is where we find the reference to the 5-year housing land supply and housing delivery test as being evidence of an unmet need. So just a brief tangent in respect of housing needs specifically. Policy HOU 3 confirms that there's a requirement to plan for a 5-year deliverable supply of housing with an appropriate buffer, and the standard method is incorporated at Annex D of the NPPF for decision-making purposes. Just for completeness, Policy HOU 4 also requires specific identification of locations of large-scale development. But it should be noted that Annex A confirms that where the calculated housing need is greater under the standard method than the need identified in an adopted development plan, provided the authority can show 75% housing delivery over the last 3 years, then the failure to meet the higher need under the standard method won't trigger paragraph J, i.e. it won't constitute evidence of an unmet need for 5 years from that plan option. But coming back to the general principle of the exception, there is, of course, no requirement to rely on 5-year housing land supply and the housing delivery test, although where that's the case, obviously it would be relied on as evidence. But it's perfectly possible to argue that there's other evidence of housing need. And it seems likely, well, of course, the policy doesn't only apply to housing, and it seems likely that we'll see this exception being relied upon in the context of a wide swathe of different development types, including things like renewable energy and logistics. There is also at Lim H a new provision which supports housing and mixed-use development, which is in reasonable walking distance of a well-connected railway station, subject to some provisos, i.e. the development has to be physically well related to that station or the settlement it lies within, and of an appropriate scale. So this is a wholly new concept and uses new terminology that I will turn to in a second. So it should be noted that Policy S5 does not apply to the Greenbelt or local green space. Those should be dealt with under their own separate policies. And where development is not inappropriate development under those Greenbelt policies in particular, it's stated that the presumption in favour of development applies. Finally, just moving on to the next slide. Oh, not got it on the next slide, but just finally, Policy S6 confirms that in relation to housing, the benefits of approval are likely to be substantially outweighed by the adverse effects where a proposal would conflict with a neighbourhood plan that's been adopted within the last 5 years, and that neighbourhood plan contains allocations to meet its housing need. So note that it's no longer enough to have policies to meet a need, there have to be allocations. And it seems likely that in districts where neighbourhood areas do not have identified housing targets, as is going to be required in the NPPF under Policy HO2, or potentially where it's not possible to rely on allocations under the local plan, this protection may be a little way off. But of course, how this policy is applied remains to be seen. So in summary, we're retaining a presumption in favour of sustainable development, but with many more layers than we previously had under paragraph 11. So we have similar, though tweaked wording in relation to substantially outweighing adverse effects rather than the language of significantly and demonstrably that we're using currently. And whether this is a higher test, of course, remains to be seen. However, of potentially more relevance is the requirement in other policies of the new NPPF that decision makers should give substantial weight to various benefits, for example, benefits through meeting the golden rules and incorporating good design. So as a consequence, it will presumably be far harder to find that these benefits are outweighed when applying the presumption. So we have some other new terms. Well-connected railway stations is the prime example. These are defined in footnote 26 as stations within a top 60 travel to work area, located partially or fully within England by gross value added, and which have at least 2 services an hour in one direction. So there's certainly going to be an opportunity here, but we're given quite a rigid definition, and it doesn't seem that any allowance has been made for a more subjective exercise of judgment as to what may be well connected. So we also have some redefinitions. For example, existing buildings, which are supported under policy S5, applies only to buildings which are in place at the date of the new framework. However, the crucial consideration in the new presumption is, of course, whether or not you're within a settlement. And that's not so clearly set out. So we do have a definition in the NPPF, and that's copied in full on the slide. And it seems a fairly black and white distinction where the local plan provides settlement boundaries. But where this is not the case, and there are no defined settlement boundaries within the local plan, for example, for smaller villages, whilst we're told that hamlets and scattered housing will not count as a settlement, there does seem to be a significant grey area and the potential for a significant amount of subjective judgment to be applied here as to whether or not you're within a settlement. So there are undoubtedly going to be opportunities to argue that sites are within settlements, but also we're potentially going to see arguments being made essentially on a twin basis, both that the site is within a settlement, but in any event would fall within the policy S5 list of exceptions. So a lot to work through here, and of course we're going to have to wait to see whether the final NPPF does clarify any of these considerations, or if they're going to be clarified post-publication once they start to be applied. But I'll now hand over to Marco to deal with changes to the green belt.
Hello, everyone. Hopefully you can all hear me. So the government, it's fair to say, looking at the consultation draft, there have been some changes, but overall, the government hasn't pulled back from its greenbelt policy and the changes really that were introduced in the existing framework. But as I say, there are some important changes here, and also sort of change of emphasis in certain key areas that I think is important to consider. The 5 greenbelt purposes still remain, which, as we know, is A, checking the unrestricted sprawl of large built-up areas, B, preventing the merging of neighbouring towns, C, assisting in the safeguarding of countryside from encroachment, D, preserving the setting and special character of historic towns, and then E, assisting in urban regeneration by encouraging the recycling of derelict and other urban land. Now, of course, when it comes to determining whether land is grey belt, it's only A, B, and D of those green belt purposes which are directly relevant, and whether or not it makes a strong contribution. Greenbelt guidance will be set out in Annex E, which forms part of the consultation document, and that will form the principles for identifying whether land is grey belt. And that assessment will be easier if the proposal to remove footnote 7 makes its way into the draft. And of course, we have had some conflicting inspectors' appeal decisions. We're all very familiar with the well-publicised South Staffordshire and Marlow, and in the case of South Staffordshire, where the inspector agreed with the local planning authority that land was not grey belt because of the impact it had on a local church. That now has been challenged, and consent to judgment was agreed just before Christmas, which will see that decision go back. So I think obviously the removal of footnote 7 will be a welcome clarification in relation to that. But then, of course, after grey belt is assessed, then if land is grey belt, then of course it's a case of then applying the rest of the policies in the framework with reference to the benefits and the harm. And in the same way as the rest of the consultation draft, the green belt section is split into plan making and those decision making or national development management policies, as they're now known as. So if I could go into the next slide, please, Jamie. So looking at plan making section first, and paragraph 145 of the current framework makes it's clear that once established, green belt boundaries should only be altered in exceptional circumstances. Consultation draft GB3 will allow greenbelt boundaries to be altered where it would enable the development of land around stations, and that's GB3 A. It's interesting because the reference here to stations everywhere else in the consultation document makes specific reference to railway stations, but here it just refers to stations. So I don't know if that's an omission, but take from that what you will. But I think what's particularly interesting with GB3A is that the important thing to note is that it's not subject here to particular need or exceptional circumstances. So that's quite an important point to note. The second limb to obviously justify the alteration of greenbelt boundaries is, of course, exceptional circumstances, and we're all aware of this. There's not a lot of change here, and when referring to being able to meet its development needs, there is reference back to policy S1 and positive plan making, which you've heard about and will be familiar from the draft itself. However, I think what's also relevant here, and it's not specifically mentioned in GB3, but I think if you're looking at promoting sites through plans, and particularly in relation to commercial development and showing sort of needs, I think chapter 7 is particularly relevant, which covers long-term economic growth. So that's definitely worth having an eye on in relation to promote those that are promoting sites and also local planning authorities. We move on to the decision-making part, which are contained within GB6 to GB9. Now, the main change, and so next, is that the next slide, please, Jamie? Apologies, you've got the next slide then. Oh yeah, sorry, that's correct. So GB7.1, that sets out development which is not inappropriate in the green belt. Now, in the most part, this reflects the current paragraph 154. The main change is GB7.1H, where development for housing and mixed-use developments, because it doesn't apply to commercial development, would not be inappropriate where A, it's within reasonable walking distance of a railway station, capable of providing a high level of connectivity to services and employment. B, is physically well related to a railway station or settlement to which the station is located, is of a scale which can be accommodated, taking into account the existing or proposed infrastructure. D, is not prejudicial to any proposals for long-term comprehensive development in the same location. And then where it's major development is a requirement then to comply with the golden rules, which I will touch on in a second. So to qualify under this and under this policy as being not inappropriate, again, it doesn't specifically reference having to show unmet need here, which is important. I think that's and I think it's a welcome addition. I think larger developments will have more scope for being able to try and make development physically well connected, potentially to train stations or settlements to which train stations are located. But as I say, there's still going to be the requirement to comply with the golden rules. And of course, it only applies this policy to housing and mixed use development. And then next slide, please, Jamie. And then in relation to the golden rules and specifically grey belt in relation to decision taking, not lots of change, but there's a few points to sort of point out here. Development's not inappropriate if it utilises grey belt land, not fundamentally undermine the purposes taken together of the rest of the green belt across the plan. There's evidence of unmet need for the type of development proposed. And of course, we know that the evidence of unmet need is reference to 5-year housing supply or housing delivery test over the 3-year period under the 75%. But I think as well, what's quite useful here when you read the consultation document as a whole, I think policy E2 and those decision making policies for meeting the need, again, for businesses, land and premises would be relevant, I think, if you're trying to make a case for unmet need in relation to commercial development. So that's something to look for. Thirdly, the development would be in a sustainable location. And then also in the case of major development involving the provision of housing, the development complies with the golden rule. So of course, I think as well, there's a useful clarification here, because it's clear that if you comply with policies 1 to 3 and you're not major housing development, then you gain the benefit of being not inappropriate development in the green belt. And if that's the case, when you look then at cross-reference to policy S55 elsewhere in the consultation document, that of course at that point it's then a case of applying the benefits against the harm as set out in the rest of the policies in the framework. Of course, if you're major development, you have to comply with the golden rules to be able to then say you're not that you take advantage of this policy as being not inappropriate development. But also you get something else in your favour, which is significant weight. So of course, if you've got a particularly contentious site that's having an impact on those footnote 7 type, matters of harm, impact on heritage assets, etc., that obviously could be quite significant in terms of being able to potentially tip the balance in your favour. So next slide, please. If I may, you got the next one? Yeah. So in terms of the golden rules themselves, we're all familiar with the golden rules. Not lots of change in relation to this, but it's what's particularly interesting here is the government has is potentially opening the door to viability assessment at application stage in 3 circumstances. Firstly, if the site is previously developed land. Secondly, in relation to multi-phase strategic sites, and then also for development which is wholly different to that which inform the viability assessment in the local plan. Now, I think that's a welcome change, but as I've said on the slide, need to just be mindful here when we look at this in the context of the general policy on viability in the consultation draft, and a couple of things that the government has is proposing, I mean, firstly, it's not specifically, as I understand it, in the consultation draft itself, but it is in the supporting documents, and that is they are talking about having a fixed national floor level where the minimum proportion of affordable housing so can't be negotiated down below a certain point, which in this case they're talking about 10 to 15% of the overall development being social rented housing. So note that's 10 to 15% of the overall development, not 10 to 15% of the affordable housing itself. So that's a important point, and also a minimum for to meet or exceed plan policies. So those are scenarios where even if you can bring forward a viability case, those are the sort of minimum levels that the government is talking about. You can't necessarily go sort of below those levels, and so that's definitely a point to be aware of. And again, when you look at policy DM5 in the consultation draft, it's quite clear that the government is looking at proposing mechanisms for then carrying out reviews later on down the line. So if you're successful with a viability case and you negotiate down the infrastructure contributions or the affordable housing, then it's a case of potentially having to maybe retest that later on down the line, which can cause problems for developers, because obviously that has issues in terms of trying to impose a valuation on that site, and also can have issues when it comes to funding as well. So I mean, overall, I think the changes are positive, but yeah, there's quite a bit there to obviously unpack. So hopefully that's been helpful, and I will hand you over to Jamie.
Good morning, all. Thank you again for joining us and for sticking with us until this point, at least. I will, over the next 10 minutes or so, be covering a range of best of the rest topics. I'll cover these at pace and to highlight certain areas which may be of interest or that you would want to respond to the consultation on. And I'll begin with weighting. It's been referenced already this morning. The government says that the use of the terms great, significant, substantial in the current NPPF are not intended to imply any sort of weighting hierarchy, and the government therefore proposes to use the term substantial where any positive weighting is intended. Some commentators have mooted the term substantial denotes greater weight where it is used in the draft. That remains to be seen, particularly how it's applied on appeal and by the Secretary of State. The case of Ward on the slide there, 2024 case in the High Court, an example of where a judge agreed in the context of that case that the term substantial did not denote a greater weight than the term significant. Heritage. The government say the current heritage policies are difficult to navigate and it wants a clearer and more positive approach. I'm not entirely convinced the current paragraphs in the NPPF needed such heavy redrafting after decades of case law and consideration on appeal. I think largely well understood and settled approach. But what we have is the term less than substantial harm that we're familiar with in paragraph 215 of the current NPPF being removed. In practice, however, in my view, policy HE6 paragraph 3, when read alongside policy HE6 paragraph 4, would have substantially or materially the same effect, i.e. if a proposal does have less than substantial harm to the significance of a designated heritage asset, its significance should be weighed against any public benefits resulting from the proposal. We also have a range of new terminology to get used to in chapter 20, the heritage chapter, whether a proposal has a positive effect, no effect, harm, substantial harm, or indeed total loss to the significance of the heritage asset. There's a change of emphasis, perhaps, at least redrafting, in terms of the consideration of non-designated heritage assets. Some commentators, and I've got that comparison on the slide there, the relevant non-designated heritage asset paragraph. Some commentators have said that maybe the new wording results in a presumption that needs to be overcome. not entirely convinced yet that that's any different materially to the current position of a balanced judgment being reached, but again, we will see. Trees, very briefly, this has got some noise since the consultation draft landed. It remains the case that, as is in current NPPF paragraph 193C, under proposed policy N6 paragraph 2, development proposals which would result in the loss or deterioration of irreplaceable habitats, such as ancient woodlands or ancient or veteran trees, should be refused unless there are wholly exceptional reasons, for example, infrastructure projects where the public benefit would clearly outweigh the loss or deterioration of habitats and a suitable compensation strategy exists. What we have is one of the lawyer's favourite changes, a change of the word "and" to an "or." So age, size, or condition of a tree could justify the finding of a tree being ancient or veteran. On the face of it, it looks like that might increase the number of trees that could be considered ancient or veteran. But crucially, again, as other commentators have pointed out, any such tree still needs to be of exceptional biodiversity, cultural or heritage value, one for tree consultants to get stuck into, but I'm not convinced in opening the floodgates to more ancient or veteran trees falling in the definition. Transport. The government say it wants to move away from a predict and provide approach to transport planning, which it says can create unattractive environments dominated by cars. That continues on from the approach in the December 2024 version of the NPPF. What we see is paragraph 116 of the current NPPF being revised. That's the paragraph which gave clarity to decision makers that development should only be refused on highways grounds if there would be an unacceptable impact on highway safety or residual cumulative impact on the road network following mitigation would be severe, taking into account all reasonable future scenarios. Now, proposed policy TR6, paragraphs 3 and 4, do not include quite the same simple direction, instead requiring all development proposals to be capable of proceeding without having such an impact. There's also other changes. The policy now refers to the transport network rather than just the highway. It refers expressly to taking into account wider network improvements, and there is more detail as to the future scenarios that should be considered when assessing potential impacts. All things for transport consultants to consider, and if it comes through in the final draft, pick up in their assessment work, of course. Landscape. The reference to protecting and enhancing valued landscapes that we've been familiar with in paragraph 187A of the current NPPF is removed, and indeed the term valued landscape does not appear in the consultation draft. Instead, we have policy N2 referring to development proposals needing to consider the environmental qualities of land proposed for development, including habitats, landscape character, and natural beauty of the countryside, and then identify opportunities for those qualities to be conserved or enhanced, including through B&G requirements where they apply. Case law had largely, despite heavy litigation on this since the NPPF in 2012, but had largely settled the interpretation of paragraph 187A as currently drafted. And this seems to be perhaps an unnecessary change, but we'll need to see how decision makers grapple with this if this redrafting is taken forward. Medium development, perhaps the most significant or the change that has the most short-term impact, perhaps if it is taken through into the final draft. A new concept defined as for housing development where 10 to 49 homes inclusive will be provided, and the site has an area of up to 2.5 hectares. This follows on from the May 2025 Reforming Site Thresholds working paper. The government say this definition is also to be linked to a range of policy and regulatory easements. Policy DM2 paragraph 2 says that any local validation requirements should distinguish between this type of development and major and other types of development. Plan making must also reflect this through allocations. Policy H06 requires the allocation, or would require the allocation of 10% of a housing requirement on sites between 1 and 2.5 hectares. That's in addition to the 10% on sites no larger than 1 hectare. The consultation document recognises that SME house builders, in the government's words, experience disproportionately negative outcomes from prolonged uncertainty in negotiations with authorities and would benefit from a faster and simpler way to agree Section 106 obligations. The government is exploring the potential benefits and drawbacks of enabling developers to discharge social and affordable housing requirements through cash contributions instead of direct delivery on these medium sites, and that could be included in policy H08. Now, I will highlight that that wording is proposed in the consultation document alongside the draft NPPF. That doesn't appear in the draft NPPF itself. So for those interested in these sites and those supporting this potential change and want to respond to the consultation, do have a look at the consultation draft itself and respond on that. In addition to the changes in the NPPF, the consultation draft alongside it and the written ministerial statement also indicates there will be potential changes to how the determination of applications for developments on medium sites may be determined, for example, through reform of planning committees. The application of build-out transparency measures may be different for these medium developments than for major developments. There's a potential extension of the building safety levy exemption for these sites. There's also a proposed extension to the permission in principle threshold to allow medium development to come within this, and also changes to B&G. Moving on to B&G, got the proposed new policy on the slide there. I'm not going to read it out. What it means is that local planning authorities, if this survives the consultation, should not be setting higher than 10% B&G requirements unless in relation to site-specific allocations and where that is fully justified and deliverable. The written ministerial statement of the 16th of December confirmed that the government will exempt smaller developments of up to 0.2 hectares from B&G and will introduce a suite of other simplified requirements to improve the implementation of B&G on small and medium sites that are not exempted. It's also expected that DEFRA will consult on what is called additional targeted exemptions for brownfield residential development. Those consultations haven't begun yet. We'll wait to see. New settlements. The current paragraph 77 requires local planning authorities to, if appropriate, identify suitable locations for larger scale developments such as new settlements or significant extensions to existing villages and towns. Policy H04, in my view, goes further and states that the development plan should identify suitable locations for large-scale developments, such as new settlements, new urban quarters, or significant extensions to existing settlements. Policy PM1, paragraph 2, as Paul mentioned earlier, requires spatial development strategies to identify broad locations for strategic development, including new settlements, major urban extensions, major cross-boundary developments. So I think greater support for those larger scale sites. Viability, Marco's already touched on this. I won't go into too much detail. My view is policy DM5, as proposed, is perhaps more prescriptive than paragraph 59 in the current NPPF. The current approach requires applicants to demonstrate whether particular circumstances justify the need for a viability assessment at the application stage. Policy DM5, paragraph 2, provides examples, but critically not a closed list of the circumstances where a viability assessment may be justified. It's worthwhile looking at those, certainly viability consultants looking at those and responding to the consultation if required. As Marco said, there is support for review mechanisms that's found in DM5, paragraph 6. The government's view, as expressed to the inspectorate by a letter sent around the same time as the launch of the draft NPPF in consultation, is that following on from its position expressed in the consultation on the London viability consultation before Christmas, is that the use of Section 73 applications to revisit fundamental issues of viability or planning obligations should be scrutinised carefully. And it's expected that a robust justification should be required for changes to those obligations that go beyond the specific variation of condition being sought. Generally speaking, the government are currently viewing dimly using Section 73 as a route to reopen those viability discussions. However, the consultation says the government do recognise practical constraints associated with the current process for modifying or discharging planning obligations in Section 106, capital A, and the government intends to undertake a wider review of this framework. And my final slide, planning application procedure. A few points here. Pre-application. Policy DM1, as proposed, says proposals for major development should be informed by early engagement with neighbours, local community and local planning authority and other bodies, and says that that should be proportionate to the nature of the scheme and those likely to be affected by it. I think that appears to go beyond current paragraphs 40 to 43 in the NPPF, which don't say there should be engagement despite supporting it, of course. Validation, policy DM2, paragraph 1, local validation lists should include the information at Annex C to the NPPF, effectively a national validation checklist. And paragraph 2 to policy DM2, local validation lists should only include additional information requirements if there is a policy in the development plan requiring such further assessment, and only where it's proportionate to the scale of development and its potential impact. So I think clarity on validation requirements undoubtedly welcome. I question at the moment whether Annex C covers what it needs to. I think it would be helpful if that was a one-stop shop covering national and legislative validation requirements. At the moment, it doesn't seem to do that. For example, it doesn't refer to the types of plans that need to be submitted or the B&G requirements that might be required by legislation. And I think it could be updated to be more comprehensive. Statutory consultees, I've said on the slide there, the new policy DM3. This was the result of a consultation that only closed yesterday on statutory consultee reform. The impact of this proposed policy effectively meaning that those consultees should only be consulted where it's necessary to do so. Sometimes that's going to be legally required, of course, and decisions should not be delayed by consultation responses unless this would allow an approval rather than a refusal. That's brilliant in terms of the wording, but that really does need to be, if taken through, applied strongly by planning officers at the coalface of planning if it's going to have any tangible impact. And finally, national model conditions. Policy DM6, paragraph 3, refers to national model conditions, which, where relevant to the development, should be used unless there are strong reasons for using a different condition. The government confirmed that they intend to develop such national model conditions and indeed national model planning obligations over the course of the next year. And on that note, I will hand back to Jay.
Excellent. Thanks, Jamie. Many thanks all. So very briefly, just before we turn to questions, I think it's worthwhile just picking up parallel statutory regimes and foul water, particularly in the context of DM7. Now I know many of us, and certainly we've advised many of you, I'm sure, on this webinar, around the objections from water authorities to planning applications on grounds of lack of foul water capacity within the relevant water recycling centre. So Jamie, next slide, please. And this is an issue that we've been advising on across the country, Anglian Water, South West Water, Southern Water, and Northumbria, many of the water authorities across the piece, and offered many opinions to support what we consider to be the correct legal approach that should be taken in these situations, i.e. one has the parallel statutory regime under the Water Industry Act and, of course, the Barrett Welsh Water case that confirms there is a right to connect to the public foul water system. And as a consequence, decision makers, in essence, shouldn't be refusing planning consent or indeed imposing occupancy restriction on grounds of lack of foul water capacity. Now, of course, there's differing approaches across the country. Many authorities are adopting this particular approach, and other authorities at the moment are being a little bit more resistant. And many of us that have been grappling with this issue have been looking at the consultation framework and reforms to see whether or not government can move the dial further forwards. Now, I've put the current wording of the NPPF on the screen, paragraph 201. There's two critical components here. Ultimately, planning decisions and determination of application should concern land use. That's point number one. And secondly, decision makers should assume that pollution control regimes and parallel regimes should operate effectively. So essentially, there's no need to duplicate through the planning system. Now, moving on to the wording of policy DM7, which is on the next slide, the initial component remains, as we can see from paragraph 1. Development proposals should be assessed on the basis of whether there would be an acceptable use of land. So that in principle component remains. The remainder of the policy, however, in my mind, does help move the dial a little bit further forward, and in particular in two respects. I think, first of all, DM7 now says that planning decisions should not duplicate controls imposed by separate regulatory regimes. Now, I think that subtle change is important because that completely removes any debate I'm aware that the likes of Anglian Water have been raising as to whether or not the current paragraph 201 does apply to the Water Industry Act regime or not, and should otherwise just be confined to environmental permitting and pollution control. So I think that's helpful. We also have a little bit more helpful wording that ultimately those regimes should be operating or assumed to operate effectively unless there is clear evidence to demonstrate otherwise. And now, hopefully, that should now shift the onus onto the likes of Anglian Water, the water authorities, to demonstrate harm and to demonstrate why the current regime is not operating effectively. I'd like to think that's a high bar that decision makers, when granting planning consent, would take into account, but ultimately is going to be one of judgment. So ultimately, whilst these tweaks are helpful, I personally, like many of us, would have quite liked government in this consultation to go further forward. I think this is a point that ought to be picked up as part of the consultation, and I think we can be stronger to essentially say that, in only rare circumstances should it be the case that planning decisions are refused, conditions imposed, because we've got the parallel statutory regime. Absent that, it doesn't change the practical position. I think ultimately, if you have schemes that are grappling with objections based on foul water capacity, that then obviously get in touch. I think the key thing is encouraging local planning authorities to take those into account, but ultimately have the confidence to rely on the parallel regime as a matter of judgment and issue decisions nonetheless. So that's a very, very quick, I appreciate, whistle-stop tour of the NPPF and associated reforms. We will be picking up matters in a little bit more detail at our forthcoming planning seminars. We have biannual planning seminars, and we've got these scheduled for the beginning of and middle of March, and details will follow along with the slide deck. But we can now move on to questions. Many thanks everybody for answering or asking questions. A huge number of questions within the box at the moment. I'll pick a suitable victim, I think, to answer these at the appropriate point. I think first of all, just picking up, running these in order. One for Morgan, I think, in terms of whether or not plan making policies are irrelevant to decision making, and indeed vice versa. I think maybe Morgan, is that one that you can pick up?
Yes, that's fine, Jay. Thank you. I think I touched on this point briefly earlier, but essentially, plan making policies shouldn't be relevant to decision making. But it's quite possible that there will be scenarios where decision making policies may influence plan making.
Yeah, and entirely agreed, Morgan. I think this is something that decision makers as a matter of judgment, examiners as a matter of judgment, are going to have to grapple with through the local plan process. A couple of questions around interpretation, which I'll very briefly pick up. One relating to how do we define a hamlet versus a village? This is relevant, of course, for the purposes of, 2 points. One, settlement. Settlements essentially include villages for the purposes of S4, S5, and separately in the context of limited infilling in Greenbelt for the purposes of what is not an appropriate development. Standard lawyer answer, matter of interpretation. At the end of the day, we don't have any definition of hamlet v village within the NPPF. There have been appeal decisions that have picked up on this point, and of course, relying on Oxford Dictionary definitions and so on and so forth. Not necessarily whether or not there's a fast food outlet, but a church in Britain at least is one of the components to direct towards a village as opposed to a hamlet. But ultimately one that would need to be considered on a case-by-case basis. So I think a similar point of interpretation around limited infilling for the purposes of S5 outside of settlement boundaries, limited infilling within groups of houses. Again, that's a matter of interpretation. There's been a number of appeal decisions I've seen that require sort of entire infilling between, for example, a row of houses where there is a gap. You've got to fill the gap in their entirety. And there's been some appeals that have said, well, actually, even if you've got a little bit of green land left where there is a gap, then actually that's not infilling. And then limited, unfortunately, is a matter of planning judgment. So no definitive answers, but one that ultimately needs to be assessed on a case-by-case basis. I would suggest. We've got a question here around the situation where development plans aren't necessarily planning for grey belt release and development around train stations and ultimately how does that sit? Does that pave the way for speculative applications, for want of a better phrase? And I'll turn to Beth for this, who's picked this up as part of her presentation.
No, absolutely. So I think kind of the first point is obviously, we should be seeing plans adopt, green belt release, consideration of grey belt, and potentially, railway stations, if development is being pushed towards them, will start to appear in local plans. But at the moment, certainly, I think it is highly likely that kind of the positive release for grey belt and development around railway stations and that presumption won't be picked up in local plans. So I think in a situation where there, just is no reference in the local plan, particularly railway stations, that's a new concept, then I don't think there will be a conflict. So, the national decision-making policies will be applying in support of those applications. Similarly, if we do have contrary policies, we're told that those contrary policies should be given reduced weight. So kind of quite simply, we have got the presumption in favour of grey belt release and railway stations. So provided, your proposal is in accordance with the relevant provisos, your railway station is well connected, or you're complying with the rules in the grey belt policies, then certainly I think there's an opportunity for applications there, and those, could very well be supported. And actually an opportunity that potentially should be looked at sooner rather than later, while those local plans are silent on those factors.
Fantastic. Thank you, Beth. Entirely agree. There's a question here around where do mayoral officers sit as strategic planning authorities, which is one that Paul, can you comment on that as part of the plan making piece?
Yeah, so the definition of strategic planning authorities can be found in Section 58 of the new Planning and Infrastructure Act. Mayors are not specifically referenced in the definition. I think, however, for practical purposes, mayors, especially elected mayors, will have a significant role to play going forward for the regions where they've been elected, because there will be strategic authorities that will have those powers where mayors will obviously exercise considerable influence. And bearing in mind, of course, that this system is very much based on the situation in London with mayoral powers in London, I think it's inevitable that from a practical point of view that will happen. And also bear in mind that the government's proposals for devolution envisage that elected mayors will also have significant powers in decision making in relation to infrastructure projects as well. So I think the shift, if indeed it continues, and as I said, we may have a different government in 3.5 years' time, who knows, but certainly on the basis of these current envisaged scenarios, I think mayors will have significant powers, including the preparation of spatial development strategies going forward.
Wonderful. Thanks, Paul. I think we've got a couple of minutes time for a couple more questions. I think we've got one here. What's the current position with regards to the review of the BNG regime? Jamie, one for you.
Yeah, absolutely. So we had the written ministerial statement before Christmas, which confirmed that the 0.2 hectare exemption will be brought in. I suspect that will need a change to the secretary legislation that deals with the exemptions. That may well also be introduced alongside some other nips and tucks following the consultation on B&G reform last year. It's my understanding that the consultation on B&G reform last year had 25,000 responses, but the government are working on those, and a DEFRA announcement said that they're expecting the response to that consultation to be issued in the new year. So I think alongside that, the third thing, I suppose, and new legislation to bring in the exemption and perhaps some other tweaks, the response to the consultation formally. And what we're also going to get is a targeted new consultation on particular exemptions for residential developments on brownfield land, and that is to be forthcoming. So I think B&G is here to stay, but it might change, particularly around the smaller sites. The other thing to mention, of course, is we'll also see further progress this year on it applying to DCO schemes, NSIPs as well.
Excellent. Thanks, Jamie. Very, very quickly, just a question around BNG and how ultimately development plan policies sit that may require higher BNG or other BNG requirements that cut across the framework. Ultimately, standard rules, development plan is the starting point. Framework is a material consideration of significant weight. So in practice, I'd like to see decision makers using the framework policies to effectively trump the development plan. I think before wrapping up, just to say there's a question here around timing. We obviously have until the 10th of March to get our consultation in. There's 225 odd questions through the consultation document that we need to grapple with. There's going to be a huge amount for government to wade through. I personally think it's likely, I don't have any intel, I'd welcome views, but I think it's likely that we'll see something in the summer. The whole purpose, for example, of making NDMPs non-statutory is speed. So I don't think government are necessarily going to hang around, but I think it's one that we'll have to just wait and see. Otherwise, thanks very much for all the speakers, and most importantly, thanks everybody for joining us today. Hopefully, we've answered all questions. If there's anything that we haven't managed to answer, we'll endeavour to come back separately in writing or alternatively pick up the phone. And along with the slide deck, we'll be circulating dates for your diaries for our in-person seminars across the Eastern region and the Midlands for the beginning of March. So many thanks everybody for joining us, and I hope you all have wonderful days. And thanks very much.